Welcome to the Deep Dive. Today we are really embarking on quite a journey. We're looking at sources that stretch across, what, 4,000 years?
That's right, 4 millennia. From the very earliest Mesopotamian laws, the cuneiform tablets, all the way up to modern reports on carceral states. It's a huge sweep.
And the mission here is to see what this vast timeline tells us about something really fundamental, isn't it? This enduring tension between justice, social order, and, well, truth.
Exactly. It's a massive stack of material, as you can imagine. But what really jumps out almost immediately is this kind of ancient echo.
An echo, how so?
Well, these sources, and we're talking excerpts from historical analyses, the Hadith, legal panels, contemporary reports, they suggest something pretty startling right from the get-go.
Which is?
We tend to think that the really deep, stubborn problems in our modern legal systems, things like systemic corruption or why justice feels so elusive sometimes.
We think they're modern problems, products of our time.
Precisely. But the sources, they argue, no, actually many of these aren't fundamentally legal problems at all.
Okay, so what are they then?
They're the result of these underlying, often clashing moral or philosophical principles that society kind of baked in millennia ago.
Ah, okay, so that's the core tension you mentioned, this sort of aha moment from the sources.
That's it. The ancient world, it seems, was really quite aware that some of the basic building blocks you need for a civilized society, well, they're actually incompatible if you push them too far.
Incompatible, like oil and water.
Kind of. They're embedded in the very recipe of civilization, and they create this internal stress that, never fully goes away. It just has to be managed.
Okay, let's unpack that. You mentioned freedom and equality as an example. We hold those up as these twin ideals, right? Modernity's pillars.
We do, but think about it. If you chase absolute freedom, the total right to control your own fate, grab every opportunity, what happens?
Well, some people get really good at grabbing opportunities.
Exactly. You inevitably end up with huge amounts of wealth and power concentrated in a few hands. And that destroys equality.
Okay. And the flip side?
If you go for absolute equality, you have to impose some pretty serious limits on what individuals can do, on their freedom, their initiative.
So you can't max out both at the same time?
The sources argue you can't. It's not a problem to be solved. It's a tension to be constantly navigated, balanced.
And there's a similar tension right within the law itself, isn't there?
Yeah.
Between the rule of law, like having fixed rules, and individual justice.
Absolutely. It's a classic one. The rule of law needs certainty. It needs clear, consistent rules applied predictably, right?
Same rules for everyone, more or less.
Generally speaking, yeah, regardless of the specific sob story. But individual justice, that demands nuance. It wants to look at the particular person, their life, their context, their intent.
In modern law, it tends to lean towards certainty, doesn't it?
Overwhelmingly. We try to achieve it by writing incredibly detailed laws, trying to cover every hypothetical situation. But the consequences.
Sometimes the result just feels wrong, unjust for that specific person.
Exactly. And the problem, as the ancient jurists apparently saw it, is that when certainty wins like that, the injustice doesn't just vanish, it sort of hangs around, it festers in society.
That really does sound like a blueprint for why things often feel so perpetually stuck, why the quest for justice never seems quite finished.
It might be.
So, okay, why dig back to 2100 BC? How does looking at Sumerian laws help us with today's problems?
Because our fundamental goals haven't really changed. We want order, we want justice, we want security. The Babylonians wanted the same things.
Just with different tools, maybe?
Different tools, yes. But the sources make this compelling point. Sometimes our modern methods are actually less successful than the ancient ones.
Really? How so?
Because we're still tripping over those same fundamental philosophical conflicts. By looking at the roots, at how these legal structures were first built, you get this kind of shortcut.
Yeah.
You start to see the historical architecture of these conflicts and why the same cracks keep showing up today.
Okay, let's start at the beginning then. Mesopotamia, the dawn of written law. We're talking codes like Ur-Nammu, Lipit Ishtar, and of course the famous Code of Hammurabi, around the 18th century BC for Hammurabi.
That's right, but it's crucial to understand how they even got to writing laws down. It wasn't some philosopher king having a revelation.
No, what was it then?
It came out of administrative chaos, basically. Think about the city of Uruk, way back, maybe 3500 BC.
Yeah.
It exploded in population.
How big are we talking?
We estimate it went from maybe 25,000 people to potentially 100,000 in just a few centuries. Imagine trying to manage that, feeding them, housing them, defending them.
You couldn't just keep it all in your head.
Absolutely not. And that's where writing comes in. The earliest forms, pictographs, then cuneiform. It wasn't for poetry or history.
It was for accounting.
Exactly, it was an accounting system.
Yeah.
Tracking grain, livestock, who owed what labor, practical stuff. Only centuries later did rulers think, hey, we could use this tool to write down the rules of society.
That leap from tracking barley to divine law, the image of the god Shamash handing the laws to Hammurabi, that's a huge conceptual shift.
Monumental. But then the question becomes, how did they actually use these written laws in court? Because their approach was radically different from ours.
Okay, how so? This sounds important.
This is really the crux of it, philosophically. In those Sumerian and Babylonian courts, the judge, they were expected to be guided by the written code.
Guided.
But, and this is key, they were not bound by it. The written laws were seen as a resource, a kind of statement of principles, maybe precedents.
So the judge had a huge amount of wiggle room, discretion.
Massive discretion.
Yeah.
Absolute, really. They were free, expected even to look at the specific situation, the people involved, their character, and then apply their own sense of justice, what felt right in that particular case.
Wow, that sounds appealing from the perspective of someone seeking justice. But it's the total opposite of modern legal thinking, isn't it?
Completely. We demand that the written law prevails. Certainty trumps everything else.
Which leads to that idea.
Yeah.
If it's not explicitly forbidden in writing, then it's permitted.
That's the tradition it fostered, yeah. Because the law has to try and specify everything, so you end up with this contrast. The ancient world had courts of justice, guided by a moral compass, you could say.
Whereas we mostly have courts of law, bound by the text.
Pretty much. And connecting back to the bigger picture, the sources suggest this gave ancient judges an edge. They could use the law to correct for moral principles that seemed off in a specific case. Modern judges, they often have to apply principles they know are flawed in that instance because the text dictates it.
Okay, so if the judge isn't just applying the letter of the law, how did they figure out the truth? How did they establish facts? The sources mention 4 main ways in Sumerian courts.
That's right, 4 main methods. The ideal, the gold standard was always hard evidence, physical proof.
Like what?
Well, Hammurabi's Code, Law 266, says if a shepherd loses an animal to, say, a lion, he has to bring back the carcass to prove he didn't just steal it or sell it.
Makes sense. Catching a thief red-handed would be even better, I suppose.
The best case, absolutely.
Right.
Direct proof.
Okay, what if you didn't have hard evidence? Next up was witnesses, right?
Yeah.
And we saw earlier how important social obligation was. That plays out here.
Hugely. Tampering with testimony was a serious offense because the whole system relied on people telling the truth. Namu's Code, Law 25, hit perjury hard.
Oh, hard.
15 shekels of silver. Now, to put that in context for you, sources suggest a shekel of silver might be like a day or two's pay for a really skilled worker back then. So 15 shekels, that's not trivial. It's a substantial fine.
Okay, definitely not a slap on the wrist. But what really caught my eye was the penalty for just refusing to testify.
Ah, yes. Law 26 in Ornamo. If you were summoned to court as a witness and you refused to show up and testify under oath,
What happened?
you had to pay the entire value of the lawsuit you refused to participate in.
Wow, the whole amount.
The whole amount. It wasn't really about punishing silence itself. It was about enforcing this incredibly strong social duty to participate in finding the truth. If you opted out, you were seen as actively sabotaging the state's ability to function, and you paid the price.
That's a heavy obligation. Okay, third method. The oath before the god. This sounds like where religion and law really merged.
Seamlessly. It was often used when the human evidence was contradictory, when the court just couldn't decide based on testimony or documents alone. The divine became the tiebreaker.
Is there an example of this?
Yeah, there's this great little story about a man named Ikushuni. He had a dispute over ownership of a house. His opponents claimed his ownership tablet. His deed basically was a forgery.
So conflicting documents. The court couldn't tell which was real.
Exactly. So what did they do? They made Ikushuni take an oath. He went to the temple of the goddess Inanna, swore before the god that his claim was true, and that was it. His title was cleared. The divine oath trumped the human doubt. It settled the matter.
Okay. Which brings us to the fourth method, the one that feels the most alien to us today, the river ordeal.
Ah, yes. The trial by water. This pops up in a few ways. Namu's Law 10 uses it as a test of innocence. Someone accuses you of sorcery, say. You're taken to the river. If the river proves you innocent, meaning you survive somehow, then your accuser pays a fine.
But Hammurabi used it as a punishment too.
He did. Law 143 is pretty specific. If a wife was seen as a gadabout, neglecting her home and humiliating her husband, she could just be thrown into the water, presumably to drown.
It just seems so random,
Yeah.
arbitrary. How could they accept that as justice? What was the thinking?
It only makes sense if you share their underlying belief system. You have to believe the river ordeal wasn't random, that it actually reflected the will of the gods. The river god was acting as this impartial, final judge.
So it wasn't about finding the human truth of what happened.
Not primarily, no. The analysis and the jurors panels really honed in on this. The goal was achieving acceptable certainty. Think about it. If you have a case with conflicting evidence, no clear proof, no resolution in sight, that doubt can fester. It can lead to blood feuds, social breakdown.
So the ordeal provided a definite answer, even if it wasn't, factually accurate by our standards.
Exactly. It provided a final, unchallengeable decision, attributed to the gods. Certainty, even a potentially wrong certainty, was sometimes seen as better than paralyzing, unending doubt. It brought closure.
That need for closure, for restoring balance after a wrong, leads us right into the next big topic. How ancient law actually dealt with injury. And there were these two big competing ideas, right? Restitution and talion.
That's right. Two fundamental principles you still see echoes of today. First is restitution. This is basically the foundation of our modern civil law.
Paying damages.
Exactly. Compensating the victim, usually with money or goods, to restore the economic balance that was disrupted by the injury. But this system, it needs infrastructure. You need cities, courts, a reliable state, usually a monetary system. It's organized compensation.
Okay. And the other principle, talion.
Talion, lex talionis, the law of retaliation. An eye for an eye, a tooth for a tooth. This appeals to a much more visceral instinct.
Did it even?
Pretty much. The idea is that the guilty party has to suffer damage equal to the damage they caused. It's swift, it's direct, often doesn't need a formal court. Think nomadic cultures, desert justice.
When we look at the really early codes that survive, like Ornamu or the laws of Eshnunna, which one dominates?
They lean heavily towards restitution. There's this striking emphasis on rational restraint. They put a price tag on injuries rather than demanding an actual eye for an eye.
Quantifying the damage.
Right, and the economics are fascinating. Take Urnamu's code, maybe around 2100 BC. How much for knocking out someone's tooth?
You said earlier, 2 shekels of silver.
2 shekels. Now, breaking someone's foot, 10 shekels. Using our rough guide of a shekel being maybe a day or two's skilled wage, a foot was worth maybe 2 weeks' work. Still restitution, though.
Okay.
Yeah.
But then things changed.
Just about 125 years later, under the laws of Eshnunna, the prices jumped dramatically. Suddenly, a tooth costs half a mina, and breaking a foot, also half a mina.
Wait, a tooth and a foot cost the same. And how much is half a mina?
30 shekels.
30. So like 6 months' wages for a laborer for a tooth?
Yep. Huge jump. It could be inflation, or maybe society just started valuing physical integrity much, much more. But the key point is, even with the price hike, both Urnamu and Eshnunna are focused on monetary compensation. They're trying to avoid actual physical violence in the penalty.
But then comes Hammurabi, around 1750 BC, and things get harsher.
Much harsher. Hammurabi's Code is where we see, for the first time in the surviving legal record, the introduction of physical mutilation as punishment, literally an eye for an eye in some cases, and even more shockingly,
The execution of innocent people.
vicarious punishment, yes. It's a real shift.
Why the change? Hammurabi's code is huge, isn't it? Hundreds of laws. Is it consistently brutal?
No, that's what's interesting. It's inconsistent. Many laws are quite moderate, focused on contracts, administration, things like that. But then you get these sudden bursts of extreme brutality.
So what explains that inconsistency?
The historical analysis points strongly towards a clash of cultures. Hammurabi himself was an Amorite.
Amorites.
Yeah.
They were originally nomadic.
From the West.
Exactly. Essentially, a tribal leader from a desert nomadic background, the Martu, they were called, who had conquered the ancient established city-states of Sumer and Akkad.
So you had the sophisticated city culture with its restitution-based laws.
Right. Written laws, courts, bureaucracy.
Colliding with the Amorite desert culture, which probably favored.
Italian, feud justice, quick reciprocal violence, oral traditions.
So Hammurabi's Code was maybe a compromise, trying to glue these two worlds together. That's the argument. It was a massive political and legal act of consolidation. When the crime involved high-status people or threatened the core structure of the city, Hammurabi often seems to default to the harsh reciprocal Italian principle. Maybe to satisfy his own Amorite power base, the desert constituency.
So these two fundamentally different ideas of justice, restitution, and talion are just kind of jammed together in the same code.
Awkwardly coexisting, yeah. Which brings us to that really disturbing part. Vicarious punishment. Killing an innocent to balance the scales. How on earth did they justify that?
It seems unthinkable.
The logic, however grim, comes from combining talion with the ancient principle of property.
Okay, how does that work?
For thousands of years, across many cultures, a man's wife, his children, his slaves, they were legally considered his property, like his ox or his house.
Right.
So if someone injures your son, they haven't just hurt a person, they've damaged your property.
Okay.
And talion demands reciprocal damage. Equal damage must be done to the offender's property to restore balance.
So, let's take the example from the code. Law 230. A builder builds a shoddy house, it collapses, and it kills the owner's son.
Talion plus property logic dictates the builder's son must die.
To make it even. Minus one son on each side.
Precisely. The source material points out the cold logic of balance was satisfied, but at what cost? Human innocence is destroyed. It's a terrifying example of how dehumanizing that property principle could become when fused with the demand for reciprocal harm.
It really highlights how central property was. And beyond injury, the stability of the whole city-state rested on another core unit, the family. The laws were pretty strict about keeping that unit together, weren't they?
Absolutely vital. Survival depended on family cohesion. Look at Sumerian Law 4. If a son has the audacity to say to his father or mother, "You are not my father," or "You are not my mother,"
What's the penalty for essentially disowning your parents?
the harshest one available short of death. He could be sold into slavery for money.
Sold into slavery, just for saying that.
It shows how seriously they viewed undermining parental authority. It was seen as an attack on the very foundation of social order.
But it wasn't just a one-way street, was it? Parents had obligations too.
Crucially, yes, it was reciprocal. Law 5 says if the parents turn around and disown their son, "You are not my son," without a really good reason,
Then what?
they forfeited their entire estate, their property. It shows that within that family structure, the law demanded mutual duty. Parents and children were held equally accountable before the court when it came to maintaining the family unit.
Okay, now we have to address something that was just accepted back then.
Yeah.
Slavery. How did the law handle the ownership of people?
It was just a fact of life, accepted pretty much everywhere for millennia as part of this necessary hierarchy. Society was seen as layers of dependence holding fragile communities together.
And the laws reflected that acceptance.
Consistently. What's really striking is the stability of certain laws related to slavery. For instance, the reward for catching and returning a runaway slave.
How much was that?
2 shekels of silver.
The same price as a tooth under Ornamo.
Exactly. And that 2-shekel reward stays the same in Hammurabi's code 300 years later, despite all the other price inflation we saw with injury fines.
What does that consistency suggest?
It implies a really stable, fixed value placed on that specific service, retrieving valuable property. But even within this rigid system, there were nuances.
Like what?
Well, we have archaeological finds like a cylinder seal, a personal valuable item used for signing documents belonging to someone named Ishtar Lamasi. And her inscription identifies her specifically as the slave girl of Ninasina.
So even someone legally classified as property could own something personal and valuable like a seal.
It seems so. It suggests a level of personhood beyond just being chattel. And the jurist panels analyzing this stuff, they contrasted it with modern individualism. They suggested the ancients might look at our society with its tendency to break down natural authorities and family links as deeply unnatural. Back then, even within a strict hierarchy, people had a place, a sense of belonging, not just isolated individuals.
That sense of belonging and property principles also shaped marriage and divorce, didn't they? Hammurabi Law 138 is pretty blunt about the purpose of marriage.
Explicitly links it to bearing children, yeah. That was the primary legal function.
And this framework, how did it play out in divorce settlements?
Actually, in quite a precise and arguably equitable way, given the property focus. If a man divorced his wife and they hadn't had any children,
What did he owe her?
he had to give her back the full amount of her bride price, what he or his family paid to her family initially, and he had to return her dowry, the property she brought into the marriage from her own family.
Why both?
The dowry was often understood as being intended to support any children she might eventually have. By returning it, the law ensured she wasn't left destitute and that she had resources to potentially support children with a future husband. It's a strict application of property rules, but the outcome aims for her independence and future provision. Pretty sophisticated, really.
And one last fascinating detail from this era, breaking off an engagement, jilting someone, that was actually a legal issue.
Oh, yes, breach of promise. It was actionable under both Urnammu and Hammurabi, because an engagement wasn't just romantic. It was a binding future contract involving property transfer and the expectation of procreation.
And that concept lasted for a remarkably long time, didn't it?
Millennia. Breach of promise lawsuits were a thing in Western law right up until the mid-20th century.
What finally killed them off? A change in morality.
Nope. Technology. Specifically, reliable contraception.
Ah, because that broke the automatic link between sex and having children.
Precisely. Once that link was severed, the whole legal and social scaffolding around betrothal, which was fundamentally about ensuring legitimate heirs and managing property transfer related to children, just kind of dissolved. The ancient laws became irrelevant almost overnight because the underlying biological reality had changed.
Okay, so we've journeyed from these ancient laws rooted in property, reciprocity, and city survival. Now, let's fast forward quite a bit. How did the rise of monotheism, specifically Christianity, reshape legal thinking in the West?
It introduced a profoundly different framework, especially regarding retribution. You move away from direct reciprocal justice like Talion. Think about the Ten Commandments or the Sermon on the Mount in the New Testament.
What's the key shift?
Individuals are essentially asked to relinquish their personal right to vengeance. Instead, punishment is assigned to God. Vengeance belongs to me, I will repay, says the Lord.
That sounds like a precursor to social contract ideas, where we give up rights to the state.
It's a very similar structure, yes. First, the covenant is between humanity and God, who handles ultimate justice. Later in secular thought, the covenant shifts to be among individuals who grant the right to punish the state as their agent.
And did Christian thought bring in other concepts we see in modern law, like humanism?
Absolutely. The strong emphasis on forgiveness, mercy, and tolerance, particularly in the New Testament, provides a deep philosophical root for what we now call humanism in criminal justice, treating offenders with a degree of compassion.
What about equality?
That's another huge one. The theological idea that all people are sons of God, all equally flawed by original sin, translates into a legal principle: equality before punishment. The law should, ideally, be applied without discrimination based on social status. That was a major departure from many ancient systems, where penalties often depended heavily on who you were.
Okay, let's shift eastward now to the Mughal Empire in India. That presents a different model, right? More of a mix of legal systems.
A fascinating example of legal pluralism, yeah. The Mughals ruled a vast, diverse population, primarily Hindu, while being Muslim rulers themselves, so their justice system had to navigate that.
How was it structured? Who administered justice?
Day-to-day justice was typically handled by judges called qazis. They were often assisted by muftis, who were like legal scholars. A mufti would issue a fatwa.
Which is like a legal opinion.
Exactly, based on Islamic law and precedent. But it wasn't usually binding on the qazi, more like expert advice.
And how did they handle the mix of religions? Did Muslims and Hindus face different laws?
It depended on the type of case. For serious criminal matters, the Mughal state tended to apply its own law based on Islamic principles, fairly uniformly across the population. That asserted state control.
But for other things, like family law, inheritance.
There, especially under emperors like Akbar, there was a real effort towards pluralism. They tried to integrate Islamic legal principles with existing Hindu customs and traditions. It was pragmatic, aimed at social harmony.
Did that last?
It varied. Later emperors, like Aurangzeb, leaned towards a stricter, more codified application of Sharia law. But even then, there was often still room for judicial discretion. If a specific situation wasn't covered by written law, the qazi might rely on general principles of equity and good conscience. It was a complex, evolving system.
This brings us to specific Islamic penalties, the hudud. These are punishments set out in religious texts, right?
Yes, hudud literally means limits or boundaries established by God in the Quran or through the Hadith, sayings and practices of the Prophet Muhammad. The penalties are fixed and often severe, intended as strong deterrents against crossing those divine lines.
Can you give some examples from the source material, like for theft?
For theft, the prescribed had punishment, mentioned in the Quran 5.38, is the cutting off of the hand.
That's severe.
It is. And the Hadith sources emphasize its seriousness. There's a well-known anecdote about a noblewoman who committed theft during the conquest of Mecca. People tried to intercede for her, asking for leniency because of her status.
And what happened?
The Prophet Muhammad refused, insisting the law must apply equally, even stating that if his own daughter had committed the theft, he would have applied the same penalty. It underscores the idea of these boundaries being absolute.
What about sexual offenses? Adultery or fornication?
The penalties differed based on marital status. For unmarried individuals found guilty of fornication, zina, the punishment was typically 100 lashes and often banishment for a year.
And for married individuals committing adultery?
The prescribed punishment was stoning to death, Roger.
Wow.
However, and this is absolutely crucial to understand, the standard of proof required for a conviction, especially for adultery, was incredibly high.
How high?
Generally, it required 4 reputable eyewitnesses to the actual act of penetration.
4 eyewitnesses to the act itself.
Yes, an almost impossible standard to meet in most circumstances. Many scholars interpret this high bar as being protective, designed to make convictions extremely rare and prevent false accusations given the severity of the penalty. So while the punishment was severe in theory, its application was likely very infrequent due to the stringent evidence rules.
Okay, so we've traced this arc from restitution through Talian divine law. Now let's turn to punishment itself, the consequence when justice fails or judgment is rendered. We keep coming back to that tension. When truth is hard to find, certainty often wins out, sometimes through brutal means.
Historically, punishment wasn't just about justice. It was often about public spectacle, about deterrence through terror, and sometimes about utterly destroying the condemned body and soul. The methods could be incredibly brutal.
The sources detail some pretty horrific examples. Can you walk us through a few?
Sure. Take breaking on the wheel. This was common in Europe for centuries, especially for aggravated murder or treason.
How did it work?
The condemned person would be strapped to a large cartwheel. The executioner then used a heavy iron bar to systematically shatter their limbs, striking them between the joints. Sometimes they were left on the wheel to die slowly from shock and dehydration, often displayed publicly. It was agony made into a spectacle.
Truly awful. What about impalement?
Impalement is famously associated with figures like Vlad the Impaler in Romania, but it was used elsewhere too. It involved driving a long, sharpened stake through the victim's body.
Horizontally or vertically?
Could be either. Vertically, often entering through the perineum and exiting near the shoulder or neck, carefully avoiding vital organs to prolong the suffering. Victims could sometimes survive for days, displayed on the stake as a gruesome warning.
And then there's scaphism. The boats. That sounds bizarre.
Scaphism is attributed to the ancient Persians. It's one of the most grotesque methods described. The victim was placed inside a narrow boat, or sometimes between 2 boats fastened together, with only their head and limbs sticking out.
Okay. Then what?
They were force-fed large amounts of milk and honey
Milk and honey, why?
to induce severe diarrhea. They were then left, often floating on a stagnant pond or in the sun, covered in this mixture and their own excrement.
Which would attract?
Insects. Vermin. They would essentially be slowly eaten alive, dying over days or even weeks from dehydration, starvation, septic shock, and the burrowing insects. It was torture designed for maximum degradation and prolonged suffering.
Unimaginable. And in China, there was lingqi, slow slicing.
Yes, lingqi, sometimes called death by 1,000 cuts, used for high treason or patricide. The executioner would methodically make numerous small cuts all over the body.
Was the goal just pain?
Pain, yes, but also something more. The intent was often described as destroying the person's spiritual integrity, ensuring their body wasn't whole for the afterlife, preventing their spirit from returning in a recognizable form. It was about annihilation, not just execution.
It's just staggering the depths of cruelty humans have devised in the name of punishment or deterrence. But has modern punishment really become humane? Or just quieter, less public?
That's the critical question. We've largely moved away from public physical torture, yes, but punishment hasn't vanished. It's often become systemic, institutionalized, and sometimes psychologically devastating. The focus shifts.
And this is where the case study of the prison system in Pakistan comes in. Sources suggest it exemplifies how modern states use incarceration for more than just crime control.
Exactly. The reports highlight what's described as the state's prevailing criminalizing and securitizing slant. Prisons become tools not just for punishing criminals, but for managing dissent and maintaining a specific social and political order.
An order defined in this case as an Islamically homogenous nation.
That's the framing presented in the analysis. Anything seen as deviating from or threatening that homogeneity, whether it's ethnic activism, religious difference, or political opposition, gets reframed as a security threat and dealt with accordingly, often through the legal and prison system.
And this system operates within a wider context of corruption.
Pervasive corruption. The reports paint a picture of prison life defined by an economy of extortion,
Meaning?
meaning inmates constantly have to pay bribes for better work assignments, for basic goods, for protection, sometimes just for small favors from guards. You essentially have to purchase a livable existence inside.
And is this corruption seen as solvable?
It's described as incredibly difficult to root out. One former inspector general of prisons from Sindh is quoted saying, fundamentally, it's a societal problem, not just a prison problem. The prison mirrors the corruption outside its walls.
How does this securitizing slant affect specific groups? What about religious minorities?
The reports detail a practice of segregated confinement. Prisoners accused of blasphemy or those belonging to targeted minority groups like Ahmadis or sometimes Christians or Hindus are often kept separate.
Why? What's the stated reason?
Officially, prison superintendents often claim it's for the prisoner's own protection, to prevent them from being attacked by others in the general population.
But does it serve another purpose?
The analysis suggests it also serves administrative convenience, ensuring the smooth functioning of day-to-day jail operations by isolating potentially volatile situations. But the effect is clear. These prisoners are physically preserved, maybe, but they're often denied basic privileges like proper bedding or access to common areas. It reinforces their status as other, as threats to be contained.
And political dissenters. The sources mention the Pashtun Tahaffuz movement, the PTM.
Yes, the PTM is a nonviolent civil rights movement advocating for the rights of Pashtuns, especially those affected by military operations in the tribal areas. They've faced significant state crackdown.
How are they targeted?
Members are frequently arrested, often under very broad anti-terrorism laws or cybercrime laws for things like social media posts critical of the state or military. The reports mention specific cases like Nadim, a medical student who was allegedly abducted by state agents.
Abducted, not formally arrested.
Abducted and held incommunicado in secret detention centers. These places are described by former detainees in chilling terms.
Oh, so
One called them graves, places designed to extinguish hope where disappearances happen.
how did these secret centers compare to regular jails?
One former prisoner made a stark comparison. He said even the overcrowded, miserable conditions of a regular jail felt like heaven compared to the secret centers.
Why?
Because in jail, there was at least the possibility of process. Access to lawyers, family visits, a record of your existence. In the secret centers, you vanished. It shows the exercise of state power completely outside any legal framework, relying on pure psychological terror.
Which brings us to modern psychological methods, moving beyond physical pain to directly attack the mind.
This is where modern punishment can be incredibly insidious, precisely because it leaves no visible marks. Take techniques like white terror or the white room torture, reportedly used by regimes like Iran.
What does that involve?
Complete sensory deprivation, but in an overwhelming way. Everything is white. The walls, the floor, the prisoner's clothes, even the food is often plain white rice. Lights are kept on constantly. Guards wear padded shoes to eliminate sound.
What's the goal?
To erase sensory input, to destroy the perception of time, no sounds, no colors, no variation. It reportedly leads very quickly to hallucinations, paranoia, severe memory loss, and anhedonia, the inability to experience any pleasure or happiness. It's designed to psychologically shatter someone from the inside out.
And similar techniques elsewhere.
The blackout box is another example, reportedly used by agencies like the CIA during enhanced interrogation. A tiny, dark, coffin-like box providing extreme confinement, sometimes combined with sensory overload, like playing high-pitched sounds of crying children on repeat. Again, the aim is psychological collapse under acute stress, without necessarily resorting to overt physical violence. It replaces the public brutality of the wheel with quiet, calculated psychological warfare.
What an arc. We've gone from Sumerian fines for a knockout tooth through divine retribution, public spectacles of torture, and landed here with with the quiet efficiency of the modern carceral state and psychological manipulation.
It really traces how the focus of legal systems and punishment has shifted, hasn't it? From trying to restore individual balance or appease gods, towards this overwhelming modern emphasis on securing the state, maintaining social order, often at the expense of individual truth or justice.
And that core conflict we started with, truth versus certainty, it feels like it's still right there unresolved.
Absolutely. We talk a good game about individual rights in modern political thought. The individual is supposedly sacred, but in the actual practice of law, that same individual often becomes, as one source put it, an impossible inconvenience.
An inconvenience, how?
Because digging into the messy, nuanced truth of an individual case takes time, resources, and accepts uncertainty. It's much easier, much more certain to rely on procedure, on technicalities, on plea bargains, on managing caseloads. Certainty often wins over the hard work of finding real truth.
We can maybe tolerate more ambiguity than the ancients, who needed that river ordeal for closure. But the fundamental challenge remains. How do we actually get to the truth within our systems?
And maybe we've structured our systems in a way that makes it harder. Ancient law often started with the specific, if a man does X, then Y follows, and built principles from there. Modern law often starts with the abstract principle and applies it downwards, sometimes missing the human reality on the ground.
Which leads us to that final, really provocative thought from the sources, doesn't it? About the contrast between ancient community focus and modern individualism.
Right. Modern society elevates individual freedom above almost everything else. But ancient law, as we saw, was deeply rooted in reciprocal obligations, mandatory duties. The driving principle wasn't individual liberty, it was the survival of the city.
Survival through enforced cohesion.
Exactly. Their legal structure actively inhibited the unchecked growth of individual power, but aimed to safeguard everyone's life through this tightly ordered society where everyone owed duties to everyone else. Think mandatory military service, forced labor on public works like irrigation canals, that absolute family authority we discussed.
You couldn't just be an isolated individual. You were locked into the community.
Organically locked in through this dense web of enforced duties.
So, thinking about today, we see so much fragmentation, polarization, a lack of public cohesion. Does this ancient model offer any, hints?
Well, the sources invite us to consider this. If our hyper-focus on individual freedom seems to be clashing with the need for social order and shared purpose, maybe the corrective lies in rediscovering some sense of mutual obligation.
Shifting our focus.
A conscious shift, perhaps. Moving our sense of personal identity away from being purely private, purely about individual rights and desires, and toward a more vivid awareness of the public interest, of shared social obligations.
Moving from just what am I free to do towards what do I owe the community? What are we building together?
It's a profound challenge. Could rediscovering something like the ancient emphasis on the survival and well-being of the collective, albeit without the brutality or rigid hierarchy, be part of the answer to strengthening our frayed social fabric today? That's certainly something to mull over.
A powerful thought to end on, that the deep past might hold unexpected keys to our present challenges. Thanks for taking this incredibly rich deep dive with us.